For coming here today. I am going to talk about a paper that's in a draft form, so completely open to feedback, and I've called it Not So Innocent Bystanders. Perfect. Now you think about bystanders, some of us may have been a bystander. You're a third party who just happens to be in the wrong place at the wrong time, and an accident happens and you're there, or a crime happens and you're there. And we often think of bystanders as innocent bystanders, because they're just like the people at the beginning of the Law and Order episode who are like there and see something awful happen. And what I wanted to look at with this paper is the concept of a not so innocent bystander. And what I want to look at and explore is how social media has created this new kind of bystander, which are those people that just sit there and record an event as it happens, instead of helping out in a state of emergency. And that's what I call in this paper as not so innocent bystanders. Now, generally, and I just want to say as like a, what is it called, a caveat, or one of those things that you put at the beginning that you say, just so you know, I'm generally not into creating new laws, especially new penal laws, and I'm into decriminalization and all these things. But I was inspired to look into these themes this summer when I read about Jamel Dunn. And I think that probably a lot of people in this room did. Jamel Dunn was a 31-year-old man who wandered into a pond with all his clothes on in Florida. And he drowned. And it's a tragic story to begin with, but the worst part of it is that a couple hundred feet away from him, there was a half dozen people who were just watching and filming him. For over 2 minutes, they watched him die. And, you know, those of us who just came out of the evidence law panel are used to kind of shocking footage. But I actually have, it was posted to social media channels. And I have an audio just to give you a sense of what these people on the side of the pond were doing while a man was drowning.
Yeah, you get guardian. Fucking junkie. Get out the water, you gonna die. That gator's coming towards you, man. Buddy. You not finna help your ass? You sitting down there. Buddy drowning with that, man. Ain't nobody finna help you, you dumb bitch. You shouldn't have got in there. Yeah, buddy off that 40. Yeah, buddy out right, he's off the 40. Yeah, where you at? Hey, buddy off that 85.
So you guys get the idea, right? It's been on for about 2 minutes.
Wow.
And I can't figure out how to turn it on. So they just stood there. They used their phone and they recorded him for 2.5 minutes. They never called the police then or any time after. The police found out about this footage because his body turned up 3 days later. And then this had been circulating on social media in the meantime. So they ended up charging the individuals who filmed this death instead of helping with the failure to report a body to a medical examiner, which was the only way that this wrong fell within the penal code in Florida. And it got me thinking, what would happen when this happens in Canada? Because it will. Because that's all we do these days is record stuff on our cell phones. They're ubiquitous. So when this happens in Canada, how prepared are our criminal laws to deal with this kind of situation? And should we reconsider our whole concept of the innocent bystander in light of this kind of wrongdoing, this separate wrongdoing in the context of both doing nothing and then posting it to social media? So that's what I want to talk about today. So the problem, as far as I see it, is there's two wrongs. There's the failure to assist, and then there's the wrongdoing of posting this failure to assist to social media instead of using your phone to call the police. That, I feel, is like the least you could do in the state of an emergency. And right now, the criminal laws that we have that would deal with the failing to assist is very much, we are not equipped to deal with this kind of wrongdoing. So it's very firmly entrenched in our common law that bystanders do not have a duty to help anybody else out. That's Canadian common law. That's in our criminal law as well. So I went through the criminal code, and if any of you criminal smart people out there think of a thing that I've missed, let me know, because this is a draft paper and I'm open to suggestions. But I thought, could bystanders be parties? Could it be the failure to stop at a scene of an accident? No, because that only applies to people in cars. criminal nuisance, the duties tending to the preservation of life, and criminal negligence all require a duty to do something that you didn't do. And then they look at those common law categories where a duty exists, which are generally close relationships like parents, caregivers, teachers. I saw cases where police were held accountable, but there has to be a very specific undertaking that I will help you out, and it's a high bar. So as far as bystanders go in the Jamel Dunn situation in Canada right now, there wouldn't be any kind of criminal liability, I don't think. And then there's the second wrongdoing here, which is posting a non-consensual image of you in a state of an emergency not being helped. So circulating this image of a very traumatic event in a person's life to the internet at large. And I was trying to think about the ways the circulation of this image of somebody not helping you in a emergency situation could be liable. And again, I don't think it would be based on what we have in our criminal code right now. The closest thing that we have as far as a penal punishment for the circulating of an image on the internet is the new revenge porn laws, where you can be penalized for the publication of an intimate image without a person's consent. But what happened to Jamel Dunn would not qualify as an intimate image, in that there was no reasonable expectation of privacy, and that happened in the middle of a public place, in the middle of the day, out in public. So as it stands, I don't think what we have in our criminal code captures what I really see to be the tragedy that happened to Jamel Dunn, which is where people are just standing around filming something with their phone and posting it to social media instead of helping out somebody else. And so I got to thinking that maybe it's time we start punishing bystanders. And there's two reasons why I think maybe we should reevaluate our staunch common law stance of no bystander liability. And the first one is that social media has incentivized doing nothing in an emergency. And this is how it's done so. So online communities exert an incredible amount of pressure on people's lives, and they've become increasingly important. So, there's lots of studies coming out of the United States right now that show that the average teenager spends 9 hours a day on social media. 13-year-olds check their social media accounts 100 times a day on average. And the social currency on these platforms are followers, they are friends, they're shares, these kinds of actions that people take on social media when they encounter exciting contact expand a person's social network, which makes people feel good the same way drugs make people feel good. They've actually had psychologists look at the brain centers of your brain that get shot off when you look at your social media accounts, and it's the same addiction networks that fire off when you take drugs or alcohol. So it's these kinds of physiological, social, and there's even financial incentives to post exciting content on social media that I know from watching The Bachelor. It's now an actual profession to be a social media influencer. If you have a lot of followers, if you have a lot of likes, if you are considered influential within these online communities, you get free things, you can get paid to take pictures of yourself with things, and you can actually turn that into a career. But more so than that, I think there's the whole social incentive to do nothing but post these exciting content onto your social media networks. So the second reason why I think we should revisit bystander liability now is that social media has created a new context for harm to occur to the person who's depicted on the video. So in these emergency situations, a person's undergoing a really serious psychological or physical emergency situation. And once it's out on the internet, it's difficult to control the dissemination of that image so that the person depicted in it is continuously re-traumatized. These are the kinds of arguments that were advanced in the context of the revenge porn statute. But you can't stop your grandparents from seeing it, your children, prospective partners, prospective employers. It's just out there and you can't control it. And that creates a whole other area of harm for the person who didn't agree to be filmed that day in this emergency situation where a person chose not to help out. So these are the arguments why I think maybe now social media has changed the context in which bystanders may be not so innocent anymore. So this is why it's fun to be a grad student, because then I can just go ahead and write a statute. And this is what I think it could maybe look like. And it's a mishmash of statutes that exist in the United States and in Quebec that create a duty to assist. as well as the dissemination of an intimate image prohibition in our criminal code right now. And a couple things that I want to point out about my proposed solution here is that it's very limited in its scope. So if we were to punish bystanders, this would only apply to the people at the scene of an emergency. So very limited scope. You'd have to be physically present there filming with your phone and not just in the vicinity. So another thing I want to point out is there's limited circumstances. So in order to trigger a duty to assist, you wouldn't have to put yourself in danger. So for instance, if the teenagers in Jamel Dunn's situation didn't know how to swim, then they'd be putting themselves in danger if they wanted to go try and help them. So this duty to assist wouldn't be triggered. And also if you had a duty to another, so if I was there on the side of the beach or whatever with my kids, and they could wander into the water and drown themselves if I went out to help Jamel Dunn, then again, this duty would not be triggered. So there's a couple defenses built in there, right? And a very limited circumstance where the duty to assist would be triggered. As well, there's a defense in there for public good. So if you post your footage to social media and somehow it's good for the public, so it's newsworthy or it helps in the detection, the prosecution of a crime, then you'd have this positive defense against any kind of liability under my imaginary statute I'm proposing today. And then another thing that I want to address is that there'd be very limited punishment. I don't want people to go to jail for not assisting. I see more something in the order of prohibition orders where a judge could, have some kind of discretionary remedy where they could limit the amount of time this person spends on the internet. Because the whole idea, the whole problem as I see it, is this disconnect between humanity that social media has created. Kind of want to rip people out of that, and I think prohibition orders would do that. So that's the kind of penalties I would envision in these kinds of circumstances. So why not punish bystanders? So whether or not to punish somebody who just chooses not to help someone else out has been bandied about by philosophers and legal academics for decades. And there's a lot of really good reasons to not punish omissions, and by and large I've been on board with these up until this summer. And so the first one is indeterminacy. And that is if you decide to start punishing omissions, where does your general duty of beneficence start and where does it end? Like, what are exactly your duties to help out? What is reasonable in the circumstances? So in Jamel Dunn's situation, it's clear that the people who were standing on the side of the lake filming him while he died had a duty. But what about the people in the houses all around the lake who heard him flailing about? Did they have a duty to assist? And what about his family that didn't stop him from leaving the house that day? Would they have a duty to assist? So I would say that this is a legitimate argument against punishing omissions, but with a properly drafted statute, that it can be limited. So you'll note that if you draft a statute that's limited in its application to the individuals who are there at the scene of a crime, you can meet this concern. Another reason why you shouldn't punish bystanders has to do with omissions and identity. And this is a philosopher named Andrew Semester who's posited that a person's identity is knowing and intrinsically tied to knowing that your actions have consequences in the world at large. And that if you impose a collective responsibility for omissions, you dilute the accountability for wrongdoing. And that's important to an individual's identity. And it could even lead to the absurd result that people who are feeling less accountable for their actions in the world at large will do more wrong things. So you try and penalize things, and then all of a sudden people are doing a lot worse things because they know that they're not individually accountable. Again, I think the proposed statute is applied in very limited situations to a very limited group of people. And so this concern about weakening a person's accountability and identity would be minimized, or could be minimized if you wanted to. A third argument has to do with autonomy, and that imposing liability for omissions impacts liberties to a greater extent than imposing punishments for positive acts. And again, a really good argument, but I would say that in this particular circumstance, the limitations on a person's autonomy would be minimal. So how many times in your life are you actually faced with a circumstance where you choose to do nothing in the face of an emergency but film it? Probably not that many times, right? And then the only choice that you're taking away from a person with this proposed legislation would be the choice to do nothing. And so again, I think that the incursion on your autonomy would be minimal, because it wouldn't come up very often, and the choice that you're taking away isn't a very good one. Finally, there's two more. There's charter arguments, and these were advanced in relation to the Cyber Safety Act in Nova Scotia. So Nova Scotia tried to enact a statute that tried to curb cyberbullying, and it was found to be unconstitutional because the definition of cyberbullying was found to be overbroad. As well, it contained no positive defenses. And again, I think that those charter arguments could be met with the present statute. Finally, there's practical reasons, and that is that social media evidence has become a really valuable source of information for the detection and the prosecution of crimes. And that if you create a penal code or a penal statute like the one I propose here, you would have a chilling effect on this potentially viable source of prosecution evidence. And again, I think that if you build in a defense where if your social media evidence can be used for a public good, like the detection and the prosecution of crimes, that you wouldn't trigger liability, or you'd have a defense to your actions under this proposed legislation. So in closing, I just want to quote Cocoa Mayor Harry Parrish when he was asked if he was going to start imposing liability on teenagers after Jamel Dunn's situation, or bystanders who do nothing. And he said, you got enough laws. You can't legislate stupid. And, he could be right. The kind of legislation I promote here could just be a reactive law that creates more problems than it would solve. Or, on the other hand, maybe social media has changed our society to the extent that we need to legislate stupid.